Welcome to the Supreme Court of the United Kingdom, where today and tomorrow we're hearing the appeal in the case of Pakistan International Airline Corporation and Times Travel. Details of the case can be found on the Supreme Court website if you follow the link from cases to current cases. But in a word, what the case is concerned with is the doctrine of duress in the law of contract, and the basic issue is whether a contract can be avoided on the ground of duress where lawful act or threat are made by one party against the other. I'm hearing this case with 5 of my colleagues. Deputy President of the Court, Lord Hodge.
Good morning.
Lord Lloyd-Jones. Lord Kitchen.
Good morning.
And Lord Burrows.
Good morning.
In fact, 4 of my colleagues. I'm thinking that the panel as a whole is of 5. We're going to be hearing first submissions on behalf of Pakistan International Airlines, and their counsel is Philip Shepherd, Queen's Counsel. So I'll turn now to Mr. Shepherd and invite him to begin his submission.
My Lord, so as to provide you with an indication of the route I intend to follow in my submissions, and subject to any contrary indication from my Lords, I intend to develop my submissions as follows. First, a summary of the appellant's case on duress, which we submit should form the basis of this court's approach. 2, our submission as to the policy rationale for duress and the effects of overlooking it, and why a rule-based approach does not accord with policy or authority. Thirdly, our submission as to the content of common law duress as it appears in authority in this jurisdiction, including in particular Lord Justice Staines' judgment in CTN and Gallagher, and the approach suggested recently by Lord Justice Leggett in the case of Al Nahyan and Kent. And I will then include a brief reference to the academic commentary, of which there is, my Lords, as you will have seen, a great deal. Fourthly, a brief examination of authority from other common law jurisdictions. Fifth, an analysis of the reasoning of the Court of Appeal and their reasons for rejecting lawful act duress. And I will also look at the proper role of good and bad faith and why we say that the reasoning of the Court of Appeal was erroneous. 6, a short reminder, very short reminder of the key facts as found by Mr. Justice Warren and why he was right at first instance to find that the appellant entered into the new agreement under duress. And finally, some observations on the arguments advanced by the respondent. My Lords, first of all, the summary. My Lords, at the heart of this appeal is whether, when seeking to avoid a contract for duress, illegitimate pressure can ever include lawful means. Put another way, can the qualifying pressure be either unlawful or illegitimate pressure? And what does illegitimate pressure include? Should lawful acts be automatically disqualified and the inquiry end there? Or should a more holistic and less rule-based approach be taken that doesn't get trapped in semantics and focuses at all times on whether the court should really be seen to assist those who obtain consent to a contract or the variation of it by force that amounts to coercion? we say that hard bargaining is one thing, but coercion is quite another. And that experience shows that those cases where a contract should be set aside for duress or coercion, the terms are interchangeable, are driven by the facts and are more or less obvious. My lords, until the Court of Appeal handed down judgment in this case, the answer consistently provided in authority has been that lawful means are not disqualified. This is because, although the law often regards the use of unlawful means as illegitimate, thereby lessening the importance and impact of the demand in the case of lawful threats, in the case of lawful threats, the nature of the demand that the lawful threat supports becomes crucial in determining whether the threat and the demand amount to duress. Put another way, in the case of unlawful acts, the nature of the demand may assume less importance, but in the case of lawful acts, the demand assumes center stage. So we say that duress can exist if the threat is one of lawful action, but whether it does depends on the nature of the demand. My lords, no court has, or indeed should, we submit, attempt a hard and fast definition of what illegitimate pressure is. Just as in the case of fraud, the same ought to apply, because the possibilities are endless and the categories are not and should not be closed. And the justification for what Professor Bigwood called throwing out the baby with the bathwater appears to be elevating certainty, whatever certainty may mean, above the principle that it is wrong to enforce a contract that was made under illegitimate pressure. In any event, we say that no more uncertainty exists about the content of duress or its application than many other doctrines, and the search for certainty can become a rhetorical device deployed by those who insist on an extreme approach to enforcing contracts that shields those who behave badly from being called out for their conduct. So with that introduction, let me be clear from the outset what we say the court should find as regards duress. I break this down into the following points. 1, the rationale informs the content of duress. The rationale for allowing a contract to be avoided for duress is apparent consent that was induced by pressure exercised upon it by the other party, which the law does not regard as legitimate, with the consequence that the consent is treated in law as revocable. 2, the rationale does not dictate any limitations on what qualifies as illegitimate pressure. And it is for that reason that the cases have repeatedly made reference to illegitimate pressure. That is a deliberately open-ended characterization. It follows that harm or threats of harm to the person or to property can constitute duress. So can economic pressure. Thirdly, pressure may be illegitimate if it consists of unlawful or improper conduct. So the real issue in each case is whether pressure has become coercion, and for that reason is illegitimate. Coercion and contract are antithetical to one another. Fourthly, unlawful action or threat of unlawful action may be one form of illegitimate pressure, but a threat to do an act which is in itself lawful can amount to illegitimate pressure if it's coupled with an unjustified demand. And uncoupling the pressure from the demand is as mistaken as it is in the crime of blackmail. Fifthly, if the facts reveal a course of conduct beginning with a breach of contract and continuing into the application of threats designed to prevent a party threatened from getting or keeping what is rightfully his or hers, then the mere fact that lawful means are in the end used to apply the pressure does not matter. And the reason it doesn't matter is that it is artificial and wrong to focus only on the immediate means of applying pressure, rather than the course of conduct that in reality it forms part of. Sixthly, if the threat is contrived in the sense that it is exploitation of something whose only real purpose is to apply pressure so as to extract consent, and whose object is to extract money or avoid a liability, such a contrivance is likely to be considered illegitimate. We submit that we have the paradigm example in this case. 7, the demand coupled with a threat to commit a lawful act should be regarded as illegitimate pressure if the victim objectively has no reasonable, let me put it another way, if the victim objectively has, not the victim, I'm sorry, if the coercer has no reasonable grounds for making the demand, and B, the threat would not be considered by reasonable and honest people to be a proper means of reinforcing the demand. 8, treating good or bad faith of the alleged coercer as determinative is mistaken, because it focuses wrongly on the motives and state of mind of the alleged coercer and has nothing to do with whether the party alleging duress was forced to contract. At best, good and bad faith is a factor, but no more than this, in assessing the legitimacy of the pressure in question. It can never be a question that is determined by the beliefs of the alleged coercer, no matter how unreasonable that belief is, because that makes the alleged coercer the judge in his own cause, with inevitable results, the results being the neutering of the doctrine. It will become, we submit, the default setting that will, in practical terms, render the doctrine of duress, if not very difficult ever to prove, so difficult that its practical utility will disappear. 9, and this is the final point, if it is considered that duress requires further refinement, the approach suggested by Lord Justice Leggett in Al-Nahyan and Kent, by transposing an objective approach to blackmail, is the one that the court should adopt. On this basis, a demand coupled with a threat to commit a lawful act will be regarded as illegitimate if A, the defendant has no reasonable grounds for making the demand, and B, the threat would not be considered by reasonable and honest people to be a proper means of reinforcing the demand. In this case, the Court of Appeal did not engage with that test on the basis that it was not supported by authority in one very brief paragraph. So, my lords, although this may be an area where, in a commercial context, lawful threats or action to qualify for duress, English law has applied a standard of impropriety or unconscionability rather than technical unlawfulness in deciding whether conduct amounts to illegitimate pressure. In referring to expressions like unconscionability or words like unconscionability, I don't mean to confine that to doctrines of equity. My lords, we submit that it is a mistake to view the conceptual crux of duress in this context as singularly a matter of defective consent on the part of the party seeking to set aside the contract in question. Since to do so is to overlook a critical feature in contractual duress cases, the nature of the conduct in question, or more particularly the wrongful quality of the pressure applied by the alleged coercer to achieve the intended action, is what ought to be the focus of inquiry. Now, nowhere is this more plainly acknowledged than by Lords Wilberforce and Lord Simon of Blaisdell in their dissenting advice in Barton and Armstrong. The Lords in the bundle, and this will be our first foray into the electronic bundle, at page 949, in a joint dissenting judgment, Lords Wilberforce and Lord Simon, page 121 of the judgment. I'll take it that your lordships are with me unless somebody indicates otherwise as regards the reference in the bundle, where my lords say just above letter D, they say the action is one to set aside an apparently complete and valid agreement on the ground of duress. The basis of the plaintiff's claim is thus that although there was apparent consent, there was no true consent to the agreement. The agreement was not voluntary. This involves consideration of what the law regards as voluntary or its opposite. But in life, a life of commerce and finance, many acts are done under pressure, sometimes overwhelming pressure, so that one can say that the actor has no choice but to act. Absence of choice in this sense does not negate consent in law. For this, the pressure must be one of a kind which the law does not regard as legitimate. Thus, out of various means by which consent may be obtained, advice, persuasion, influence, inducement, representation, commercial pressure, the law has come to select some which it will not accept as a reason for voluntary action. Fraud, abusive relation of confidence, undue influence, duress, or coercion. In this, the law under the influence of equity has developed from the old common law conception of duress, of threat to life or limb, and it has arrived at the modern generalization expressed by Mr. Justice Holmes in where he said, subjected to an improper motive for action in Fairbanks and Snow. The Lord, a similar point is made by Lord Scarman in the Universe Sentinel, my lords, that can be found at page 2314. My lord, just at the end of 2314, going over the page to 2315, sorry, my lord, my computer's being rather slow. Great. My lords, at 2314, at the foot of the page, just below letter H, or just above letter H, Lord Scarman says the real issue in the appeal is therefore as to the second element in the wrong of duress. Was the pressure applied by the ITF in the circumstances of this case one which the law recognises as legitimate? Whereas Lords Wilberforce and Lord Simon in Barton Armstrong said the pressure must be one of a kind the law does not regard as legitimate. The two noble and learned lords remarked at 121D, and then the same passage to which I've drawn your lordship's attention, and thereby approves that analysis. I'll come back to universe tank ships shortly. My lords, it's appropriate, we submit, that in considering the legitimacy of the chain of events that leads to the making of the demand, to look at the entire case of conduct and not focus solely on the demand. Drawing the line between illegitimate pressure is difficult in the abstract, but much less so when considering real facts. Rule-based definitions are too hard-edged for any doctrine where conduct is an issue. And as in related equitable bases for relief, such as undue influence and unconscionability, the courts have not adopted hard-edged, rule-based, formulaic approaches to the way in which those doctrines are applied. My lords, it's a passing note that Lord Justice Steyn, as he then was, in CTN, my lord, it's page 1431, at letters G to H, where Lord Justice Steyn said, Miss Heilbronn cited a number of authorities which illustrate developments in this branch of the law. While I found the exercise of interest, I was reminded of the famous aphorism of Oliver Wendell Holmes that general propositions do not solve concrete cases. It may only be a half-truth, but in my view, the true part applies to this case. It is necessary to focus on the distinctive features of this case, and then to ask whether it amounts to a case of duress. So, my lord, it's not simply a matter of determining the lawfulness or otherwise of the particular threat. And hard-edged, rule-based approaches are unlikely to assist in getting to the heart of the matter. The illegality of the proposal does provide an indication that what is being done would constitute illegitimate pressure if used in a coercive manner. But the link between illegality and illegitimacy is no more than a useful guide. And my Lord, one of our main submissions is that the problem with fastening on the illegality manner of approaching duress and only allowing illegal acts to qualify is that it doesn't actually provide a useful guide as to whether or not the consent that was given was a consent produced by illegitimate pressure. It is not the case that all illegal acts are, by definition, productive of unlawful or illegitimate pressure. My Lord, the relationship between the two is not one of direct logic. So not all illegal acts necessarily constitute illegitimate pressure, nor need all illegal courses of conduct necessarily fall to be considered illegitimate. My Lord, whether the entity applying the pressure does or doesn't believe in the righteousness of its own cause is not determinative in any sense, and is, as I've said in my points, at best a factor. What is of paramount importance is to keep in mind from first to last the impact on the victim. And what is not permissible is to uncouple the pressure from the demand that it's designed to support. Why so? Because such a separation is not only artificial in the sense that it impermissibly seeks to alter the totality of the reality of what's going on in real life, but it also ignores the main policy rationale for allowing a party who's apparently consented to a contract, when the reality is that the consent was procured by deploying force or pressure that the law doesn't regard as legitimate. My Lord, the legal analysis must focus on the ultimate question. And the ultimate question, my Lord.
Thank you, Mr. Shepherd. Can I just take you back to a submission you made a minute ago? And it was the point you were making, I think, that threats, not all threats of unlawful acts would constitute duress. Now, I can see entirely that you may mean by that one has other aspects of duress to consider. That is the effect, the causal link, for example, on the claimant. But are you going beyond that and suggesting that a threat to do something unlawful does not constitute, in certain circumstances, illegitimate pressure?
I am. I'm saying never say never, my Lord. And the reason I say that is that one can imagine circumstances in which a party may, for example, be threatening to breach a contract. But the circumstances may be such that it is understandable in the circumstances where the party is put in a position by external circumstances where that party has no option but to present the facts as they are. Now, it's always difficult dealing in hypotheticals, but my Lord, I do go a little further, and I do say that it does not necessarily follow, either as a matter of logic or as a matter of law, that one could never think of a circumstance in which a threat of an act which could be deemed, in inverted commas, illegal that it would then follow that the pressure being applied was illegitimate. So I'm going beyond questions of causation and affirmation, and I am positing the possibility, it may only be that an unlawful act may not qualify because of the particular circumstances of that act.
Thank you.
My Lord, the legal analysis, I submit, has to focus on the ultimate question of whether the coerced party consented, or whether it is a case where the coerced party had no choice or was put into that position by the other party. To make that determination, I say there are three factors of particular importance. One, whether the demand was contrived in the sense of being manufactured or orchestrated mainly to exploit the victim for the financial gain of the coercer. In other words, but for the wish to exploit the victim to the financial gain of the coercer, would the demand have been made in the ordinary course of business? And my Lord, as Lord Atkin put it in Thorne, I shan't take your lordships to it, but it's at page 1696. He must no doubt be acting for more than the mere purpose of putting money in his pocket, but for some legitimate purpose other than the mere acquisition of money. My Lords, this point about how contrived the demand is, I submit, is a key indicator of when it is that lawful action can qualify as duress, as illegitimate pressure, should I say. And contrived demands are much easier to recognize than to define. Secondly, the second element is whether the coerced party made the promise either under protest or without prejudice, or in circumstances where it was evident that the coerced party was either doing so under protest, or even if the coerced party was silent, as in the ITF case, it was evident that the coerced party was going along or submitting to the pressure in circumstances where there was no realistic option. Or as it was put in Universe Tank Ships and ITS, there are circumstances where the silence of the bullied party does not mean that the bullied party was assenting to the pressure being applied. So the second issue is whether in the circumstances the coerced party was evidently proceeding under protest or without prejudice, or without prejudice, or whatever expression might be used. Thirdly, whether the coerced party had any reasonable alternative but to submit. Now, there is some debate, particularly in the academic commentaries, as to whether that last element really is an element of duress. but we submit that it should be. If one goes just for a moment to the decision in Alnayan and Kent, which my lords will find at page 703, my lords, at page 703, in the top paragraph, 191, Lord Justice Leggett, he was sitting at first instance, but had just been promoted to the Court of Appeal, as you'll no doubt know. He says this: it is sometimes said to be a further requirement of economic duress that the claimant has no reasonable alternative to giving in to the illegitimate pressure. The alternative view, which is preferred in Chitty and was accepted by Christopher Clark J. in Colmar, at paragraph 92, is the absence of any reasonable alternative is not an absolute requirement, but rather is very strong evidence of whether the claimant was induced by the threat or other illegitimate pressure to enter into the contract. It is also, as it seems to me, a relevant fact in determining whether use of pressure was illegitimate in cases where the defendant has not acted or threatened to act unlawfully, and the allegation of duress is based on exploitation of the claimant's situation to make an unjustified demand. My Lord knows we adopt the reasoning of Lord Justice Leggett in that case, and we commend that paragraph. So, my Lord, on the most basic level, the court, which is by definition being asked either to enforce or to sanction the avoidance of the contract in question, has to ask itself whether the law is prepared to sanction the use of the pressure in question in that particular case. Is it really necessary to have a rule-based definition of what pressure qualifies as illegitimate pressure? And what does or does not qualify? If the answer to that question is in the affirmative, how narrowly or widely should that rule be expressed? We say that adopting for the first time a rule that distinguishes between lawful and unlawful acts is far too blunt an instrument. That cannot be justified by the rationale for the doctrine. And we say, come back to the rationale every time. And the rationale will provide the answer. And that is because it focuses on the reality of the situation, and it focuses on whether the court ought to uphold a contract that's been procured in circumstances where it could colloquially be said that one party had made the other an offer they can't refuse. So, my lords, if, as in this case, one is dealing with a case where one party has been put in a position where it's common ground that it had no realistic option but to submit, and my lords, it's important to keep that in mind. It is conceded for the purposes of this appeal that the appellant had no realistic option but to submit to the pressure being exerted and to do what was demanded. One is already in those circumstances dealing with a case that demands that the party exerting the pressure has, to put it neutrally, some explaining to do. This is because contracts are axiomatically based on mutual assent, but not on the making of offers the other party can't refuse. So we submit that it is in those circumstances, artificial when carrying out the exercise that a court is required to carry out, simply to single out the question of whether the acts used to apply the pressure can be characterized as lawful or unlawful. The principal reason is that it fails to apply the rationale for the doctrine, and it fails to ask the right party what the pressure amounted to from the point of view of the party against whom the pressure is applied. And then we say that it's also artificial and wrong to focus on the means by which the immediate pressure is applied, and one must look at the entire course of conduct. We rely on Progress Bulk Carriers and Tube City, the St. Captanoglu, which is at, I shan't take your lordships there now, it's at page 2015. I'll come back to that case because it shows how a court, when considering duress, will consider the fact that a respondent is already in breach of contract, and that breach of contract sets up a situation where even if lawful means are ultimately applied to introduce pressure, it is that original breach of contract that is the source of everything that follows. Put another way, my lords, what's wrong with the respondent's case? It is vividly illustrated by what Lord Devlin said in Rooks and Barnard. My lords, I'll just give you the reference. It's page 4347. And it's true that Lord Devlin was looking at the equitable doctrine of intimidation. What he said was that all that matters is that a club has been used. It doesn't matter to the plaintiff what it's made of. More accurately, it does not matter what it's made of to the plaintiff. And my lord, finally, before I get on to the rationale, put another way, the supposed good faith of the coercer does not impact on, should not impact on the victim. The plea of good faith should be regarded as either, should not be regarded as a complete defense to economic duress, nor should it be a central tenet of the doctrine. Put another way, a person who puts a gun to my head and demands my wallet should be in no better a legal position because he or she is acting in supposed good faith, or has, to be less extreme, manipulated the trial process in such a way that none of the witnesses whose good or bad faith was questioned were deliberately not called, as happened here, and as Mr. Justice Warren found. It is for that reason as well why the good and bad faith of the alleged coercer should not be determinative of the outcome of duress. So, my lord, I turn to the rationale for duress, and I'll deal with it as briefly as I can. My lord, in our submission, the rationale or policy basis for common law duress existing at all is all too often given only. My lord.
Sorry to interrupt you, Mr. Shepherd, but as you're going to move on, I just wanted to ask you this question. You've referred us to Lord Devlin in Rooks and Barnard. And a question I would have for you is, my understanding is that the tort of intimidation, whether that's the two-party or three-party form, requires unlawful means as an element. It doesn't, in other words, include lawful means. And I just wondered whether that is a problem for your case.
It's not a problem for my case because I say that in duress that element isn't included. It is the case that as far as the tort of intimidation is concerned, unlawful means are a necessary ingredient. But this is where one must remember that we are dealing not with tort, where parties have not voluntarily assumed obligations as between themselves. We are looking at contract, which by definition concerns the assumption of voluntarily assumed mutual obligation. There is no logical or analytical reason as to why what the law of tort should include as being part of a remedial theory, as opposed to the law of contract, which is concerned ultimately with enforcing mutually assumed promises. So I say that conceptually and analytically, there is good reason why in the law of tort, actions that are unlawful qualify for the tort of intimidation, but that in a contractual setting, there is no reason why, when one is looking at the voluntariness of the consent given, why one should limit that analysis to lawful or unlawful acts.
Thank you.
So, my Lord, moving on to rationale. Our submission is that the crucial failure of the Court of Appeal was to keep in mind the obvious rationale that underlines the existence of duress as the basis for avoiding contracts. I say that the starting point must be that the legal presumption that contracts are voluntarily assumed obligations is paramount. The importance which English law attaches to the freedom of the parties to contract on whatever terms they choose depends crucially on the assumption that their consent to the terms of the contract has been obtained fairly. Where that has not happened, then concerns about certainty must, we say, submit to not permitting unfair conduct to prevail. Where the obligation has been forced on one party by others' improper action, the courts won't enforce the obligation apparently assumed. Now, that rationale is not limited to duress, which was the creation of the common law. It's shared with other equitable grounds for relief. My Lord, in Barton and Armstrong, in the speech of Lord Cross, and my Lord, Barton and Armstrong is to be found at page 932. I don't really need to take you there. It's something I've already mentioned, where Lord Cross refers to the passage from Mr. Justice Holmes that I've mentioned to you. What I do need to take you to, however, is Lord Diplock in Universe Tankships at page 2280, where he made it clear more than 40 years ago that the rationale or policy could not be more important when deciding the outcome of the appeal that was then before the House. And my Lord, I've said already, it's surprising how often supporters of the abolition of lawful act duress seem to refer very little to the rationale or the position of the party who's been coerced. My Lords, it's at page 384 of the report, letters A to B, where he said this. He said, "It is, however, in my view, crucial to the decision in the instant appeal to identify the rationale of this development of the common law. It's not that the party seeking to avoid the contract which he has entered into with another party, or to recover money that he has paid to another party in response to the demand, did not know the nature of the precise terms of the contract at the time when he entered into it, or did not understand the purpose for which the payment was demanded." Here are the crucial words. "The rationale is that his apparent consent was induced by pressure exercised upon him by the other party, which the law does not regard as legitimate, with the consequence that the consent is treated in law as revocable, unless approbated either expressly or by implication, after the illegitimate pressure has ceased to operate on his mind. It is a rationale similar to that which underlies the avoidability of contracts entered into and the recovery of money exacted under colour of office or undue influence, or in consequence of threats of duress." Then, my Lords, if you go on to I'll come back. There is one more passage that I'd like you to look at. It's the one that starts with the words, "The use of economic duress to induce another to part with property or money is not a tort per se." I'll read it out, my Lords, and we'll find the reference in a moment.
It's on the next page, 385B.
I'm grateful. It is. "The use of economic duress to induce another person to part with property or money is not a tort per se. The form that the duress takes may or may not be tortious. The remedy to which economic duress gives rise is not an action for damages, but an action for restitution of property or money exacted under such duress, and the avoidance of any contract that's been induced by it. But where the particular form taken by the contract that has been induced by it, but where the particular form taken by the economic duress used is itself a tort, the restitutional remedy for money had and received by the defendant to the plaintiff's use is one which the plaintiff is entitled to pursue as an alternative remedy to an action for damages in tort." My Lord will, of course, observe that Lord Diplock elevates the rationale to the highest level of dispositive importance, so nothing less than crucial to the decision. He could so easily have confined the rationale to unlawful acts, but instead he chooses the expression which the law does not regard as legitimate. So when Lord Scarman, in his speech, puts the matter beyond doubt, if you go to page 401, which is at page 2315, and my Lord, I'm going to come back to this in due course, but he says, "In determining what is legitimate," just above letter B, my Lord, "in determining what is legitimate, two matters may have to be considered. The first is the nature of the pressure. In many cases, this will be decisive, though not in every case. And so the second question may have to be considered, namely the nature of the demand which the pressure is applied to support. And he then refers to the origins of the doctrine of duress in threats to life or limb or to property, suggests strongly that the law regards the threat of unlawful action as illegitimate, whatever the demand. Duress can, of course, exist even if the threat is one of lawful action. Whether it does so depends upon the nature of the demand. Blackmail is often a demand supported by a threat to do what is lawful, e.g. to report criminal conduct to the police. In many cases, therefore, what one has to justify is not the threat, but the demand. So, my lords, we submit that no case in this jurisdiction has ever doubted either the accuracy of Lord Diplock's speech as regards the rationale for duress, which has been repeatedly cited in the cases that follow, nor has any case in this jurisdiction sought to undermine the two-part test set out in Lord Scarman, what some commentators refer to as the two-pronged approach. To the contrary, it has been repeatedly adopted. My lords, there is an article to which I will refer you but not take you in light of how much ground there is to cover. But my lords, it's an article called Contracting Under Pressure, a Theory of Duress by Stephen Smith from the Faculty of Law at McGill University. It was published in 1997 in the Cambridge Law Review. And I invite your lordships to read it. But if I can just summarize that he draws out the distinction between why contracts procured by duress are not enforced under the heading two reasons for non-enforcement. And the two reasons he gives are the duressor's own wrongdoing, which he calls the wrongdoing principle, which encapsulates the maxim ex turpi causa non oritur actio, that of course underlies the court's response to illegality. And secondly, the victim's lack of consent, what he calls the autonomy principle. And my lord, he suggests that there are two separate, although overlapping elements to duress. And as to the wrongdoing principle, he suggests that a distinction has to be drawn between warnings, I'm going to be unable to perform because the price of steel has increased, for example, and threats, unless you pay me more, I won't perform. And he asserts that wrongful does not need to be unlawful. So he also gives the example of stringing a party along and then refusing to contract when they have no other option. And my lord, that was later exemplified in Progress, Bulk Carriers and Tube City. So what we say is that looking at those two principles, the principle of wrongdoing, which focuses on the conduct of the alleged coercer, and the autonomy principle, which looks at the nature of the consent given in the circumstances. The core policy assumption is that contracts are freely assumed mutual obligations. Courts enforce those obligations because parties themselves decide to accept them. But when consent is apparently only as the product of force or pressure or coercion, then the court has to see through the appearance of consent and take note of the fact that the mutual element is absent. My Lords, Chitty at 3006 of the bundle.
Mr. Shepherd.
My Lord.
Sorry, again, can I just take you back? I'm interested in the reference to blackmail in the passage that you cited from Lord Scarman. What I think you were using that for was to indicate that a threat to do what is lawful can constitute blackmail, and the inference being that that would read across to the law of economic duress, and that the use of the word illegitimate by their lordships rather than unlawful might be regarded as indicating the same. Can I just ask you about the blackmail question? And the question I have is this: are you suggesting that all the cases where you would regard or you would submit that economic duress is made out would also constitute the crime of blackmail?
My Lords, one cannot read across directly the crime of blackmail and economic duress. One can see that there are parallels, and the reason one can't immediately read them across is that because the crime of blackmail, as it evolved through the Larceny Act and was amended by Section 21 of the Theft Act 1968, the crucial difference between the crime of blackmail and duress is that in the crime of blackmail, it is the blackmailer's belief as to whether it is appropriate to apply the pressure that he is applying that becomes front and center. In other words, the mens rea of blackmail requires the Crown to prove that the defendant did not himself subjectively believe that the method of enforcing the demand included the application of the pressure being applied. I'm not putting that very well. Let me put it another way. In the crime of blackmail, the mens rea introduces a subjective element. And the subjective element is directed at the defendant's state of mind as to whether it was an appropriate means of reinforcing the demand. Whereas in the doctrine of duress, I say that no court in this jurisdiction, until arguably the decision of the Court of Appeal, has introduced the same mens rea into duress. Put another way, it isn't the law that the alleged duressor can escape liability simply because he, no matter how unreasonably, and this is how far the Court of Appeal went, no matter how unreasonably believes that he is entitled to apply the pressure in question.
So, as I understand that answer, are you saying it simply turns on the mens rea in question, or are the other elements identical?
My Lord, the other elements are more, I would say, identical, and I don't shrink from that. If one looks at the facts of our own case, there was the appellant being confronted with a situation where the threat is not only a threat, it's a threat that's implemented. The agency is terminated, and it's just a matter of time before the termination takes effect. And he's then presented, the appellant is presented with a contract that says that he will give up all of his accrued claims to commission. Now, in those circumstances, one can see how the threat of the imminent closure of the business is one that presents the appellant with two choices. One is to accept that that will happen, and the other is to accede to the pressure that's being applied. It's not surprising in those circumstances that the appellant accedes to the pressure being applied. And it looks like what it is. It looks like the appellant being put in a position where pressure of such an intensity is exerted in circumstances where it's very difficult to see how anyone could commercially think that it was appropriate to extinguish a claim or to demand the extinction of a claim for earnings that had already accrued, producing the result of this case. So, my Lord, we say that in very many cases, if one transposes, and this was Lord Justice Legate's analysis, that if one transposes into the law of duress the same elements of the crime of duress, but one introduces an objective element as to whether it was objectively appropriate to apply the pressure that was being applied to support the demand that was being made, then that is quite a neat and elegant solution to duress.
So, I'm sure I understand this, Mr. Shepherd. Are you saying that in the present case, the actus reus of blackmail was present, and accordingly, if one adopts an objective approach to intention rather than the subjective mens rea of the criminal law, then the requirements of duress are satisfied?
I am.
Oh, okay.
And just to absolutely press you on that, if I might, Mr. Shepherd, I think I understand the answer. The language used in the criminal law is unwarranted demand with menaces. You are saying that the conduct of the defendant in this circumstance did constitute unwarranted demand with menaces?
Indeed, I am.
Thank you.
My Lord, one only has to look at the statement of facts and issues and take note of the fact that my client was being asked to give up accrued claims for commission on tickets already sold on behalf of the claimant and to give up £1.3 million of accrued commission before one looked at any interest due as a condition of being allowed to stay in business. Now, my Lord, I was just going to take you to what Professor Beale in Chitty on Contract says at 3006. It's paragraph 8-006. My Lord, where he says, no doubt in many circumstances the precise basis of duress will be immaterial, but in other circumstances it will be a matter of the greatest importance. For so long as the doctrine of duress is treated as resting on an absence of consent, or of a voluntary act, it would seem immaterial what has caused the absence of consent or the act to be involuntary. Duress would be a question of fact and not of law. Further, absence of consent would logically render a contract void and not voidable. It is clear from Lynch, my lords, we've got Lynch and the Chief Constable of Northern Ireland. It is clear from Lynch's case that all these propositions are inconsistent with the analysis of the nature of duress in the speeches in the House of Lords, because duress does not destroy the will or the consent of the putative contracting parties. It is not possible to treat the issue as one of pure fact, nor is it immaterial what caused the will to be deflected or the consent to be distorted. Whether the threat or pressure was illegitimate is a question of law. So also, because duress does not truly deprive a party of all choice, but only presents him with a choice between evils, the Lord's just pausing there, that is this case. It is not possible to inquire simply whether the party relying on duress had no choice. The inquiry must necessarily be as to the nature of the choices he was presented, and in what respect the choices differed from those ordinarily available in the market, where a person also has to choose between paying the market price and going without. The question is whether the doctrine rests on the absence of consent or on the use of illegitimate pressure, may also affect the questions of causation. On the latter approach, it may not be necessary to show that the threat was an overwhelming cause of the victim entering into the contract. So, Lord, I move then to my next point, which is that rule-based tests are inappropriate where conduct is being evaluated. In summary,
I'm sorry, Mr. Shepherd. It's just before we leave that point. Lynch was obviously dealing with duress as a defence in crime, and Professor Beale there is proceeding on the basis that the concept of duress in contract is relevantly identical to the concept of duress in crime. Is that your position?
My lord, it's relevantly similar.
In respect that it's not a question of destroying consent or voluntariness, but rather as the imposition of pressure which influences consent.
Exactly, my lord. In crime, the position is understandably more rigorous, and the demands of crime are such that in those circumstances it is considerably closer to the Lynch situation. But my lord, we say, for the reasons that your lordship has given, that what one is looking not at the destruction of consent, one is looking at presenting a party with choices between evils, as Professor Beale puts it, and that one has to look at the wider picture and consider whether the party has been forced to contract, coerced to contract. My lord, the trouble with so much of the analysis is that so many of the expressions used could be said to go round and round in circles. So one uses expressions like coercion and duress, but coercion and duress are pretty well interchangeable terms. And some commentators treat duress simply as another brand of coercion. One comes back time and time again to the policy rationale, and it isn't, if I may put it in this colloquial way, rocket science. It's quite simple. One identifies those cases where it is evident from the circumstances that one party has pushed another into making a contract that would not have been made but for the pressure being applied. I'm not looking here at causation, but I'm looking here as to the nature of the coming together of the parties and whether it's evident that one party has put the other in a position where there was really very little by the way of a choice. So put in this way. First, the policy that underlines the doctrine, which is that the court will allow a contract procured by coercion to be avoided, is because it lacks the essential qualities of freedom and autonomy and focuses instead on the wrongdoer and the nature of the actions of the alleged wrongdoer and the demand that those means support. So, for example, it shouldn't matter whether the means deployed can technically be characterized as lawful or unlawful, just as in blackmail, it doesn't matter whether the means are characterized in one way or another. Because, and this is, if I may say so, a central part of the argument, the difference between lawful and unlawful does not either logically or legally determine what the law should or should not regard as illegitimate pressure in any particular case. My Lord, the real plea advanced by the respondent is that certainty in some shape or form is much more important and self-justifying as an imperative than it is to look at behavior of the kind that is in evidence in this case. Certainty is raised up on an altar as if it were the overriding principle. Lord, they are content with rigidity because their brand of certainty is, they say, desirable, particularly in a commercial context, and because it draws a discrete veil over the conduct that has brought about the result. My Lord, we say that prescriptive lists or rules of the kind disposed by the respondent overlook the fact that they are very unlikely to achieve both the policy objective, the rationale behind duress, and to avoid arbitrary outcomes, and outcomes which are just. As we argue in section C of our case, a rule-based approach was rejected by this court in Patel and Mirza. And my Lord, I couldn't help but noticing that this morning on Lawtel, there was reported your Lordship's decision in Stoffel and Gromdower, where to which my Lords Reed, Hodge and Lloyd James are parties, in which you looked at the application of the principles that ought to apply in evaluating the Patel and Mirza range of factors. So, my Lord, what I say is that in cases where the court is evaluating conduct, rule-based analyses of the kind suggested by the Court of Appeal and supported by the respondent simply are unlikely to produce the appropriate result because they do not keep the rationale in mind. What the court ought to be doing is looking at the underlying purpose of the policy that lies behind the doctrine. Secondly, looking at any other relevant policy on which there might be some countervailing pressure. And thirdly, considering whether it is proportionate, bearing in mind that one is looking at the enforcement of a contract, and considering whether it is appropriate in those circumstances to look at the reality of the consent that was given. My Lord, what I say about Patel and Mirza is that it demonstrates how the courts have moved away from a sort of rule-based analysis one had in the reliance rule that was the product of an earlier means of solving the question of how the court should approach illegality. I take into account the fact that in the commercial sphere, courts have frequently referred to the importance of certainty. I don't by any means seek to suggest that certainty is not a desirable aim, but it is certainly no more desirable than ensuring that parties are not subjected to illegitimate pressure. My Lord, I ask you to look at a short passage from the conclusion in Professor Bigwood's article entitled "Throwing the Baby Out with the Bathwater," which you'll find at page 2887. Lord, I commend the rest of the articles to your lordship, but he says this under the heading, "Are the concepts of economic duress and illegitimate pressure so unmanageably vague so as to require their abandonment and resort to other mostly equitable categories?" He says this: "If vagueness were a sufficient reason for repudiating legal concepts and criteria, large portions of current law would be eviscerated. Vagueness to some extent is unavoidable in relation to legal rules, principles, criteria, etc., that are required to operate in the face of normative complexity, epistemological uncertainty, and circumstantial variability. The law, accordingly, is replete with vague but manageable concepts. Indeterminacy usually just calls for care in application rather than rejection." My Lord, Professor Bigwood, as particularly Lord Burrows will know, has published numerous papers concerning duress, and his most recent paper, co-authored with Professor Dietrich of Bond University, once again Lord Burrows will know well, deals with the uncertainty argument in some depth. My Lord, if you go to 2823, my Lord, the article is entitled "Uncertainty in Private Law, Rhetorical Device or Substantive Legal Argument." And he says this article addresses arguments about certainty versus uncertainty in private law, More specifically, it examines the normative weight of certainty as a legitimate end in private law theory and adjudication. For a perennial feature of commentary and curial judgment in private law, as in the law more generally, is an insistence by many on certainty and predictability as dominant juristic goals. Indeed, the legal concept is capable of being described as nebulous, is by its nature vague in its meaning, or uncertain in its application, is often advanced as a weighty, if not decisive, reason for rejecting, particularly where the concept is contested, emergent or operative at the fringes of the pocket of law under consideration. Courts and jurists often assign additional force to such arguments when considering doctrines or administering doctrinal criteria, may impact adversely on the enforceability of transactions that are commercial in nature. Lord, at 2824, in the second paragraph, in our view, courts and commentators who rely on uncertainty arguments must reflect more critically than they currently do on whether uncertainty means that too much uncertainty is, and whether what too much uncertainty is, and whether certainty is a feasible, let alone desirable, juristic goal in the relevant context or connection, all things considered. Further, they ought to assess whether the same criticisms might not equally be levelled against the vast corpus of law, insofar as it is expected to justly regulate complex interactions between autonomous actors in highly variable circumstances, with deeply intricate relationships in the face of almost inevitable factual uncertainty. In short, in order to have a genuine persuasive force, arguments from uncertainty must credibly rise above the level of assertion or speculative fear on the part of those who advance them, and be grounded instead in either experience or fully articulated reason. I'll just mention the paragraphs which I suggest your lordships could consider in due course. At 2825, he starts a section with examples of uncertainty arguments. And interestingly, he refers in the second paragraph to Patel and Mirza and the dissatisfaction with Tinsley and Milligan. And then, interestingly, at 2827, he refers to, at subparagraph 6, he says, the recent call by Davies and Day, among others, for the courts to explicitly reject so-called lawful act arrest as a legal theory. Such an open-ended doctrine, they assert, so as to place the law on a more certain and stable footing. Such a call is specifically in defence of the, in our view, lamentable decision of the English Wales Court of Appeal in Times Travel. Importantly for present purposes, Davis and Day rehearse a number of assertions about the uncertainty of a range of legal concepts, including lawful act arrest. The authors state that the basis for determining whether lawful pressure amounts to duress is a very vague test, which should be rejected because courts cannot embark on questions of moral entitlement. Lawful act duress, they say, turns on the fuzzy idea of morally or socially unacceptable conduct. Suffice it for now to observe that although this might not transpire to be the best way of formulating the test for gauging the legitimacy or otherwise of pressure applied by lawful means, it does seem rather odd to suggest that the courts are not, or ought not to be, in the business of adjusting questions of moral entitlement or the legitimacy or social acceptability of conduct of those who ultimately petitioned them to dispense interpersonal justice. It's also worth noting that in the United States, lawful act duress is now a well-established aspect of the general law, but more on duress below. And then the authors at in the following paragraph look at other areas of law where uncertainty is said to prevail. 2837, revisiting duress and unlawfulness of the pressure applied. It's too long a passage to read, but I do invite your lordships to read that passage. He concludes at 2841, they conclude at 2841. Ultimately, the law cannot avoid the thorny question when successful acts of coercion by threatened demand tactics overstep the line of acceptable transaction-inducing behaviour by limiting the remit of the common law duress doctrine to threats to engage in unlawful conduct alone. The problem of determining whether the threat of lawful conduct in support of some private demand crosses the boundaries of socially acceptable conduct remains and continues to need to be resolved. So, my lord, that's what we say about rationale and what we say in response to uncertainty as being the reason for abolishing lawful act duress. My lords, I was about to move on to look at the cases themselves relatively briefly. I see the time. I was told we were going to have a 5-minute break at some stage, but I'm quite happy to press on.
Well, unless any of my colleagues feels the need of a break, I'll be happy for us to carry on until 1 o'clock. We do normally have a break, but that's when we're starting at 10 or 10:30 rather than 11 as we did today.
Very well, my lord. I'm just following orders. My lord, duress. That brings me to my second main submission after looking at rationale. And that is that courts at the highest level have deliberately refrained from confining duress, and in particular imposing a rule based on the exclusionary rule, an exclusionary rule as to what will or will not be treated as admissible, when the core issue is what qualifies as illegitimate pressure. My lord, that is not just reflected in the language chosen. The words illegitimate pressure. This is a point that Lord Burrows made extrajudicially in an article, which, if I have time, I will show you. Is that the selection of the word illegitimate pressure was deliberate because the judges were concerned not to close off the categories of conduct that may qualify as such. Lord, not until the decision of the Court of Appeal in this case has a court in this jurisdiction required the pressure to be applied to be by unlawful means, still less has it handed to the alleged coercer the right to decide whether the demand that the pressure is designed to support is reasonable or not. That, we submit, is a departure and not one which your lordships should follow. The approach of English law can be looked at starting with Lord Atkin in Thorn and the Motor Train. My lord, that's at 2260 of the bundle. And my lord, that was the case. I'm going to go through these cases quite quickly because many of them will be familiar. But 2260, this was a case concerned with whether a trade association could demand a sum of money as the price of not putting a trader on a stop list, and whether that amounted to demanding money with menaces under the Larceny Act 1916. Your lordships may say, well, what's that got to do with duress? Well, he addressed what I say is the heresy that of lawful acts not qualifying for the purposes of demanding money with menaces. My Lord, at 2260, just there's no lettering, but just in the second paragraph, he says, now the association right to what I will call an offender announcing that they'll put him on the stop list unless he pays a sum of money. I think that several of the elements of the offence of section 29 exist. They seem to me to be menace, but to menace him with a stop list. If the matter came to us for decision for the first time, I think it would be something to be said for the construction of menace, which connoted threats of violence and injury to person or property, and a contrast might be made with menaces and threats as used in other sections of various statutes. And he then looks at the way in which those are applied in various cases. He's a little further down. Lord Justice Scrutton appeared to indicate that if a man merely threatened to do what he had a right to do, the threat could not be a menace within the Act. With great respect, this seems to be plainly wrong, and I entirely agree with the criticism of this proposition made by the Lord Chief Justice in Denyer. The ordinary blackmailer normally threatens to do what he has a perfect right to do, namely communicate some compromising conduct to a person whose knowledge is likely to affect the person threatened. Often indeed, he has not only the right, but also the duty to make the disclosure as a felony to the competent authority. What he has to justify is not the threat, but the demand of money. The gravamen of the charge is the demand without reasonable or probable cause. But I cannot think that the mere fact that the threat is to do something a person is entitled to do either causes the threat not to be a menace within the Act, or in itself provides a reasonable and probable cause for the demand. So, my Lord, that linkage between the threat and the demand is taken up in later cases, and that is a passage that's quoted and requoted in a large number of cases. My Lord, I draw your attention, but do not take you to, a decision of Pow On in 1980 that discarded the earlier life, limb, and property limitation. It's at tab, but you don't have tabs, at 1910 at 1931. Lord Scarman describes the origins of duress and its gradual widening to encompass economic duress. My Lords,
can I ask you, Mr. Shepherd, just thinking about Lord Etkin in Thorn, the law of blackmail is not easy by any means to understand. In our case, in the present case, the Court of Appeal decided that blackmail would amount to duress for the purposes of the law of contract. Well, it's made this obiter dictum, but it's at paragraph 53 in the Court of Appeal judgment that blackmail is a criminal offence and thus unlawful for all purposes, including the law of duress. I'm just wondering about that proposition. Is that one that you adopt?
my Lord, what I do adopt is the notion that where lawful means have been used in order to support an improper demand, that will amount to, or could amount to, blackmail. You'll see at the end of paragraph 53, the Court of Appeal say, in considering the meaning of illegitimate, it may be noted that at page 164, this is in the Evia Luck, my Lord, Lord Goff gives the leading judgment. He says, Lord Goff achievely equated it on the facts of the case with unlawful. The question was whether the pressure applied by the union was legitimised, while Lord Scarman in Universe Tankships referred to duress involving lawful acts. The example he gave was blackmail. Now, of course, the whole argument becomes circular, because what one is focusing on is not whether, when one is examining duress, one is not focusing on simply whether the offence of blackmail is made. What one is focusing on is whether in the circumstances the threat that was made was, when linking it to the demand, legitimate in the circumstances. Now, the Court of Appeal say a threat may be lawful if used on its own, but when combined with a demand and other circumstances, turn it into blackmail. The making of the threat is a criminal offence and thus unlawful for all purposes, including the law of duress. Well, my Lord, that is logic which we say with respect is circular. What we are looking at is not whether the offence of blackmail has been committed in any particular. What we are looking at is whether the pressure applied is appropriate to be linked to the demand that was made. Now, as we read paragraph 53, it was the Court of Appeal seeking to reason that actually in all cases of duress must, by definition, amount to blackmail. Not entirely easy to follow those last few lines. That's how we read that passage.
Yes, the reason I'm raising it is that until this Justice Cook's judgment, the only example we have in the authorities of lawful act duress appears to be blackmail, insofar as blackmail doesn't involve the threat of any unlawful act. Of course, it's itself a criminal offence. Lord Atkin's dictum doesn't assist you, because in here, there he focuses on whether the person was acting in furtherance of his business interests, and was acting. Well, I don't know.
Lord, the reason that I took you to Lord Atkin's dictum is because you will see that when we come and look at Universe Tankships, it is that linkage between the pressure and the demand that forms the basis for Lord Scarman saying that lawful acts can qualify, because it is not appropriate to uncouple the lawful act from the demand. Now, it just so happens that making a demand using a means that happens to be lawful, I will report you to the police for having committed some offence. is perfectly lawful. What is not lawful is then to say, unless you give me £1,000. And that is because the threat has been contrived in order to support the demand. But as your lordship says, rightly, if I may respectfully say so, blackmail is a difficult area, and much has been said and written about blackmail and the degree to which one can carry across the fence of blackmail into the law of duress. It is a matter over which there's a great deal of debate. But what there cannot be any debate about is the fact that duress is concerned with parties who have been forced to contract as a result of pressure and coercion. And for that purpose, one cannot, I say, either logically or legally uncouple the pressure from the demand. And it is the two taken together that the law addresses. In other words, when a court is confronted with the enforcement of a contract where those two elements are present of pressure linked to demand, the court is rightly entitled, in appropriate circumstances, and of course it's been said, and rightly so, that the test is set high, not to enforce the contract in question. So, my lords, we say that the key to all this is not to uncouple the nature of the pressure from the demand any more than it is right, and I say this by way of analogy, any more than it is right in blackmail to uncouple the lawful threat from the demand. It's intellectually, one can see the comparisons between duress and blackmail, and they're obvious with respect. So just moving on and looking at.
Well, I think Lord Burrows has a question for you.
Yes, thank you. A couple of questions, if I may, at this point. I was puzzled, and I may have misheard, but you said before you took us to the Thorn case that until the Court of Appeal in our case challenged the idea of there being such an idea of lawful act duress, there hadn't been any previous challenge to that. But that would not be my reading of the Court of Appeal in this case. They're not challenging, are they, that lawful act duress exists? They are challenging the mental ingredient, i.e. whether you need bad faith, which is obviously what the Court of Appeal thought you did, as opposed to a wider concept of an unreasonable demand. But they're not challenging the notion that it exists in law, are they? Or have I misunderstood?
My Lord, my Lord's right. They do accept, and I'll look at it when I examine the reasoning of the Court of Appeal in greater detail. But my Lord is right that they do appear to accept the possibility for its existence, although they say that it exists more in dicta than in decision. But they do transpose and require the good faith, bad faith analysis to become an element of duress.
Yeah. Thank you. That would be that's helpful. The second point, I would just be interested, because it's a follow-up from my Lord Reed's point, that we haven't had a case on lawful act duress as such. but I wondered whether you were going to make anything of the cases that look like lawful act duress, but were actually explained as actual undue influence. So I'm thinking of cases like Williams and Bailey, Mutual Finance and Wetton, Norris and Zeffert, even possibly Kaufman and Gerson. Might it be that on one interpretation, they were early examples of lawful act duress?
Yes, to take but one, in Kaufman and Gerson, whereas your lordships will remember, the threat that concerned the threat to bring a prosecution against the husband who seems to have committed fraud in France, unless the wife took on the obligations that were properly those of the husband. Now, apparently, the making of that threat was lawful according to French law, but this court declined to enforce the contract on the basis that it had been procured by illegitimate pressure. But there was nothing unlawful about the pressure applied, and here, as my Lord Burrows points out, that was an early example of lawful act duress. That distinction between lawful and unlawful conduct it is simply not spoken of cases, and none of the cases that form the corpus of common law in this jurisdiction appear to treat it as material whether the threat itself was lawful or not. So, my lords, I do make the submission that there is a body of law that supports the existence of lawful act duress. Most recently, Mr. Justice Cook's case of Progress bulk carriers, because in that case, and this is particularly important, although the owners had committed a repudiatory breach of contract by redeploying the vessel that they had chartered to the claimant to another employment, what they did was to threaten, using perfectly lawful means, threaten that they would not supply an alternative vessel unless the charterers signed an agreement to the effect that they would not pursue any claims arising out of the previous repudiatory breach. But if one does what the respondents would have you do, which is to focus solely on the nature of the threat and on the threat itself, there was nothing unlawful about the threat. I'll show you the case, but you'll see that that was another example of the use of apparently lawful means. So I was just going to take you quickly to Universe Tankships itself, because indeed I was going to take you to the cases decided either by this court or by the Privy Council first. And if you would kindly go to page 2314 to 2315. Actually, I don't need to take you to it again because I've shown you that passage where my Lord Scarman says that duress can, of course, exist even if the threat is one of lawful action. And right it is that he then quotes Lord Atkin in Thorne. So, my Lord, what we say about that case and Lord Scarman's linking of the threat with the demand is, of course, relevant if lawful acts or threats can also be relevant. And my lord, if blackmail is an analogy in this context, it's also consistent that the law of contract should be consistent with the policy that criminalised blackmail. My lord, this is my next submission, as it were, and that is that the law of duress, the civil law of duress, and the criminal law of blackmail ought to at least have this consistency, and that is that in both cases, lawful acts can qualify, and there would seem to be, we submit, no reason as to why lawful acts should be disqualified. And one must remember that the principal reason advanced by the detractors of lawful act duress is that it introduces an uncertainty into the law that is, for policy reasons, undesirable. So we submit that where a threat to do something lawful is linked to an illegitimate demand, there's no reason for the law to ignore the link between the two. To the contrary, blackmail is an example of a situation where the threat to do is to do an act which is in itself lawful. So I pause just to make 3 points about universe tank ships. First is that the passage that I took you to in Lord Scarman's judgment uses the words "of course" when referring to lawful acts as qualifying. He considered it to be a statement of the obvious. Secondly, to observe that in the present case, the Court of Appeal focused on how the threat could be characterized as lawful or unlawful. And that exposes what we say is the key problem with the adoption of the lawful-unlawful approach to the application of pressure. It stops too soon and fails to go on to consider the demand that pressure is designed to support. And third, note that the absence of any of the speeches in universe tank ships to any reference to the parties' beliefs, to bona fides or mala fides, in none of the speeches was that considered relevant. The only question was whether, in all the circumstances, the demand and the pressure were such as to qualify. My lords, I'll refer you just before the break, just very quickly, to the Evia Luck, which is at page 1431. It's another ITF case where the principal question was whether one applied the lex situs, because the pressure was applied to a ship that was located in Sweden at the time. But Lord Gough gives the leading judgment, and I'll give your lordships the reference. It's 1448 at F to H, where he said, "It is now accepted that economic pressure may be sufficient to amount to duress for this purpose, provided at least that the economic pressure may be characterized as illegitimate and has constituted a significant cause for inducing the plaintiff to enter into the contract." Lord, again, there's no suggestion of a limitation that the imposition must be by unlawful means. Still less is there a suggestion that the perception of the party or the characterization of their conduct as being in good faith or bad faith has the slightest relevance. My lord, can I was going to take you to the Privy Council in Attorney General versus R, which in which the panel included Lord Stane, who of course delivered the judgment of the Court of Appeal in CTN and Gallagher, which I'll come to in a moment. My Lords, if we have time, can we just look very quickly at 2030? My Lords, this is the SAS case, as I'll call it, where one of a former member of the SAS wanted to write about his experiences, and the Attorney General sought to enforce a contract which had been signed by the soldier in question, under which he undertook not to disseminate any information that was relevant to his service. If you go to 2030 in Lord Scott's judgment, letter H7, he says there were two elements in the wrong of duress, namely pressure amounting to compulsion of the will of the victim and illegitimacy of the pressure. Whether the pressure was legitimate depended on the nature of the pressure and the nature of the demand that it was applied to support. Generally speaking, the threat of any form of unlawful action would be regarded as illegitimate. On the other hand, the fact that the threat was lawful would not necessarily pressure legitimate if the demand was not. Now, that, if I may say so, is an encapsulation of not only of what Lord Scarman says in Universe Tanksheds, but it is repeated time and again in authority both before and since. Once again, no hint of a suggestion that the good faith or bad faith of the parties concerned was remotely relevant. And I'll come to the reason why that is in a moment, or certainly in due course. Lord, is that a convenient moment?
Yes, that would be. Thank you very much, Mr. Shepherd. We'll adjourn now and resume at 2 o'clock.